Hi, everyone. Welcome to our Facebook live broadcast. I'm Steve Altition, Director of Client Partnerships here at Lander Home Family Law. I did it. As you know, we've changed our name. We are not Lander Home Family Law anymore. We are Pacific Cascade Family Law. And I'm Steve Altition, Director of Client Partnerships here at Pacific Cascade Family Law. And today, I'm here with our estate attorney, Triston Dallas, to go through the basics of a trust. How you doing, Triston?
I'm doing all right. Glad to be here once again.
I'm glad you're here again, too. So, Triston, today we're going to talk about the basics of a trust.
Yep.
So, I'm going to start with a basic question.
Yep.
What is a trust?
I mean, it's somewhat of a loaded question, but the simplest way to think of a trust is really it's a legal entity. It's different from something like a will, which really is just a document of instructions, if you will. But a trust document, a trust agreement creates an actual legal entity that is, to some extent, and depending on the type of trust, it's separate from the individual that created the entity. And that trust can hold assets and all types of things, you know, for the benefit of another individual or for the benefit of the person who created the trust.
So we talked about benefits of a person, the creator. Who are the parties to a trust?
Yeah, another good question. So usually it gets a little bit confusing for the uninitiated. But the simplest way to look at it is there are three main parties of a trust. There's going to be the settlor or grantor. That's the person who creates the trust. That's the person whose assets are usually being put into the trust. And then you have the trustee. The trustee is almost like your gatekeeper. They are if you think of it in terms of a will, in some ways they are the executor. They're the personal representative. They're the person that is going to manage the assets and the trust agreement. And then you have the beneficiary, and that's the person who's supposed to benefit from the trust, or the person that's going to receive what assets at the end of the day from the trust itself. So those are kind of your three main players from any trust agreement.
So how do you make a trust? How are trusts created in the first place?
Yeah. So as I mentioned before, for the most part, it's just a document that's created. It's an actual agreement. It's an agreement between the grantors and the trustee to manage those assets for that beneficiary. And so similar to a will, it's a document that's created, a little more formalities, a lot more work that goes into creating this type of document because there's a lot of more rules there. But simple enough, it's just a document that creates the trust.
What can you put into a trust? Are there restrictions? Can you put any asset you want into a trust? Can you put like an obligation to pay into a trust? I mean, what goes into a trust?
Yeah, I mean, I would say generally just about anything can go into a trust. There are things that you may not necessarily want to put into a trust, or you would need to have specific trust for certain things. For example, something like firearms, depending on how you're utilizing and want to pass those firearms, like, excuse me, like a gun trust itself can work. But cash, insurance policies, retirement accounts, real estate, just about anything, just about anything can go into a trust. But it will depend largely on your goals and what you're trying to accomplish with the trust itself. Like I said, sometimes some assets you just don't want to put into a trust because trusts are treated differently than if they were held in an individual's name separately.
So I've heard a lot of names for different kinds of trusts, and let's talk a little bit about what kinds and types of trusts there are out there.
Yeah. So there are a lot. I mean, you're going to hear all kinds of names for trusts. There's disclaimer trusts, and there's gun trusts, and there's personal residence trusts, and then there's A and B trusts, and then there's all kinds of stuff that you'll run into. Special needs trusts, supplemental needs trusts. at the end of the day, for the most part, it's going to be filtered down to two categories: revocable trust, irrevocable trust. Revocable trust is most people are going to call it like a living trust or like a family trust. You're going to create while you're alive for a, like I said, for the benefit of another party, which you have the ability to put assets in, take assets out kind of at your will as a grantor. Irrevocable trust, similar to a revocable trust, except it's irrevocable. Once that trust is created, once that is funded and that trust agreement is been executed, you are, the grantor is a lot more restricted as to what they can do with the assets in the trust. And without getting to super details with irrevocable trust, like you lose some rights, like the asset is quote unquote no longer part of that person's estate. And to some extent, no longer a part of their purview. But on the other side is if you want to actually remove something from an irrevocable trust, you're going to run into a situation where you might have to get the court involved. You don't have the same autonomy that you do in a revocable trust.
So in a revocable trust, let's say I put my cars or, like you said, guns into a revocable trust. I can take 3 of those guns out of it and they no longer then would pass with the trust?
Correct. If you remove, I mean, it's conceptually possible, although obviously not advisable. You can create a revocable trust and not fund it with anything. The trust entity is technically still there. It's just quote unquote dry. There's nothing in it. But if you do put assets in it and then later on you're saying, hey, I want to remove these assets, vehicles are a good one because people change vehicles relatively often. Then you take that vehicle out of the trust and you put it into the individual's name once again. Then if something was to happen to that individual and they still had that vehicle in their own name, not in the trust name, then that vehicle would end up passing through some probate process, not necessarily through the trust itself.
Got it. And if I wanted to add to that trust, I could do it without just having to make a whole new trust.
Correct. You don't have to create a new trust to add new things to a revocable trust. And a really good thing about revocable trust and the types of trusts that are revocable is that even third parties can leave assets to that trust as long as they have the correct phrasing and nomenclature. You can create a family trust and a third party that could be a grandparent or a very close friend or like a godparent or something like that of your children or of you. They can actually name your living trust as a beneficiary of, let's say, their estate or their trust or what have you.
Can I change? Did you say can I change beneficiaries or trustees?
Mm-hmm.
Both trusts, both kinds of trusts, revocable and irrevocable.
Yeah. So with the irrevocable, like I said, you're going to be a little bit more constrained on the things you can and cannot do. Changing a beneficiary in irrevocable trust is a very difficult thing to happen just because there are rights. Like I said, after you create an irrevocable trust, you're more than likely to have to get the court involved to make any changes. With a revocable trust, you can change just about anything. You can decide, hey, one day I no longer want the trust and completely dissolve it, and everything that was in the trust will go back into your name or your spouse's name or however it was listed prior to creating the trust. You have a lot more autonomy there. So if you wanted to list the beneficiary of that trust as your children, and then you decide, hey, I instead want it to be my nieces and nephews, you are not really constrained from doing so, generally.
Yeah. So kind of, I guess the question then is, why do a trust? What are some advantages to setting up a trust to transfer your assets instead of just gifting it to somebody or, putting it in a will?
Yeah. One of the main things that people do, why people create trusts, And I'll give our normal, before going into this, I'll give our normal disclaimer, if you will, is you don't necessarily need $1 million in order to create a estate plan or create a trust or have a will or what have you. But most of the time people create a will or create a trust because they want to avoid probate on the back end. So if something happens to them, they don't want their family to have to go through the probate process. But it isn't just creating a trust, you also need to fund it. So funding the trust adequately and properly is what's going to avoid that probate. But that's usually one of the main reasons. Another reason why people create a trust is, if they've had a family member that's got special needs in some way or disabled in some way and is going to need assistance beyond or after the parents have passed away, and the parents want to leave some type of funds or ability for them to be taken care of financially, that a supplemental or special needs trust is a way to do that. Or sometimes families do create trusts, like testamentary trusts, or trusts for their children until their children reach a certain age, like 21 or graduating college or 22, just in case the parent has passed away prior to that moment or prior to their reaching the age of majority. Most times, an 18-year-old kid with a significant inheritance is probably not going to make the greatest decision. So a lot of families will create a trust until they're reaching a later age.
I understand that. It sounds like both wills and trusts have and can have a lot of impact on how you transfer stuff after you die. But answer me this: is it necessary for you to die to have your trust transfer? Can you have a trust set up that pays off beneficiaries or gives stuff out while you're still alive?
Yeah, I mean, like I said, with the revocable trust, you have a lot more autonomy. You think it's something like a, conceptually, just using this as an example, like a supplemental needs trust, a special needs trust. As a third party special needs trust, a mom or dad can create that trust, fund it with assets that can be used for, let's say, their adult child that has some type of supplemental needs. And the trustee, which could not be the mom or dad, would have the ability to, use those funds for the child in some way. And that doesn't necessarily mean that the parent has to pass away in order for anything to be done or used or distributed through the trust. Now, most times what happens is the trust itself is not funded until somebody has passed away, specifically when it comes to like supplemental needs trusts. That happens pretty often. But when it comes to revocable trusts, like family trusts and things like that, most times the grantor is also the trustee. And so even though they funded it with all of their things, they are still able to utilize and do anything with those assets in the trust. So initially they are the beneficiary. They are the individual that's the trust is for. And then after they pass away, things change. And the next beneficiary is their children or another family member. And in most cases, passing of the grantors, one or both of them or all of them, usually it can make the trust change from a revocable trust to an irrevocable one, given that the grantors have passed away.
Got it. So are there any disadvantages of a trust? Is there reasons or times that you maybe want to do something different than a trust?
Yeah, cost is probably the first one. It's going to be more expensive to do a trust right away than, let's say, doing a will. Time investment also is a lot more involvement. With the will, you can, to some extent, create it adequately, try to anticipate all the different issues that your estate could run into, whether it be taxes or otherwise. And you are, quote unquote, set to go. With the trust, you have to be a lot more involved and mindful because you have to make sure it's funded. And because you're likely using the assets that you are funding it with, like a home or vehicles or what have you. Vehicles change, homes change. You have to constantly remember to put things that you are purchasing or changing or obtaining into the trust if you want them to pass through the trust. Then depending on the type of trust that you create or choose, you can end up, giving up control of some of the assets that are in the trust as well. So it can be a little more cumbersome to create a trust. I would say most times, as long as their goals are clear and they're prepared for the long haul of managing and maintaining a trust, the benefits will outweigh most of the pros outweigh most of the cons. Another thing that you can run into is some potential tax issues just with, if you're not completely mindful of some of the things that you want to put into a trust that could be income generating. Trusts, without getting too into details, trusts are their tax rates are truncated. They're not the same as individual tax rates. And, an individual would probably need to be 200,000 plus before they start, or even higher than that, before they reach the highest tax bracket and, be potentially paying about 50%, in taxes, income wise, while trusts, it's very much smaller. Can't remember the exact number, but I think it's like 12,005 before you're going to reach that like 40% plus tax rate for income generated into the trust. We'll have to, don't quote me on the exact numbers, but that just to prove the point, it's a lot lower number. So if you're generating income into a trust and you're not prepared for that properly, and the trust is not prepared for that properly, you can end up paying a lot more in taxes there. So it's just another thing that potentially needs to be considered. And that's why I said it's a little more cumbersome, because you have to pay attention to a lot more things. And not everybody's willing to take those actions and do those things, on a regular basis.
Oh, I get that. I mean, if I say, okay, when I die, you get my house and you get my cars and you get my, furniture, I just can, wait to die. I don't have to do anything. But in a trust, you buy new furniture, new cars, and new houses. You got to do stuff.
Yeah.
Yep. I get that. So trusts obviously do a ton of stuff, and they do them in different situations. And it sounds like they do a great job. But what doesn't a trust do? Are there kind of myths out there about, what? If I have a trust, it does this, or the magic trust. What don't they do?
Yeah, I would say there are some pretty common misconceptions about what a trust can and cannot do, or what the grantor or the creator of the trust should or shouldn't do. One of the first ones is, I've created a trust, and so now I'm automatically like protected from creditors, and I avoid estate taxes. It's not accurate. Just because you have a trust doesn't mean that you no longer will incur taxes. Just because you have a trust does not mean that, if you pass away, that you don't have to pay. Actually, your estate will not have to pay for your creditor, pay off your creditors or anything like that. That's not the case. Now, there are things that can do to limit your potential estate taxes, or limit the ability for some creditors to quote unquote go after certain assets, but there's a little more convoluted processes, and like I said, you're probably giving up some ability and autonomy over assets, but generally just having a trust is not going to do those things. Another thing is, and we talked about before, is like, okay, I created a trust and I want all my assets to be in there, therefore my trust is going to handle that for me. There isn't anything else you need to do, and that's also not accurate. Once you create the trust, you must fund the trust. So you can't, like I said, it's not like a will where you can create the document and say, I want these assets to go to this individual, and you're good to go. With the trust, you can list those things and how you'd want certain assets or distributions to go to children's or a specific individual. But those assets must actually be owned or entitled to the trust before they'll actually pass through the trust. So there's kind of an extra step there. But again, because you've taken that extra step, you wouldn't necessarily need to take that step again down the line, like through a probate process, which again, going back to one of the pros, one of the pros of having a trust is avoiding that probate.
Yeah.
And then one of the things that happens that people think sometimes is that the trustee is the person that owns the assets in the trust, which isn't accurate. Now, it is important to note that some things will be titled, or if a trustee is going to sign for things for the trust, the trustee will sign their name as trustee of the X, Y, and Z trust. But the trust itself is the actual owner of or where what the asset is titled in, not the trustee. The trustee is essentially there just to manage the assets and anything in the trust, whether it be cash or what have you, and to effectuate to make sure that the instructions are followed as to how distributions or anything like that is supposed to happen based on the trust document. But the trustee is not the actual owner. Those are probably the three most common quote unquote myths that I think I've run into, or questions that I run into. Probably that second one is the most common. People think they created a trust and therefore they're protected, or their assets are in the trust. And more times than you would think, somebody has a trust and there's nothing actually in it.
Yeah. So how does someone choose a trust, or begin to figure out what a trust or kind of trust might be right for them?
Yeah, like I mentioned before, it's going to be based on your goals. It's going to be based on a lot of factors and questions. Are you married? Are you single? Do you have children? Do you own a business? Do you have retirement? Is your children dealing with any type of special needs? Do you have firearms? What is your specific health situation? What planning things you want to do? Do we have to? Is there going to be anticipation? There's going to be a lot of taxes. What's your age as well? I feel like the way that a trust could, that a person may want to deal with a trust and plan is going to be different when you're 35 as opposed to 75. When you're more closer to the twilight of life, you're probably going to be a little bit more willing to do things like irrevocable trust for some reasons in order to plan to get certain assets out of your quote unquote out of your estate. So it really just depends, and having a consult with an attorney and based on your goals and what you want to accomplish, we'll be able to explain or give you options as to routes you can take, or advise you or recommend some routes you can take based on your goals. But like I mentioned before, there are so many different types of trusts, quote unquote types of trusts that are out there and that can be used. Life estates, like I said, special needs, and dealing with retirement accounts, all those types of things. And with the ever-changing legislation when it comes to estates and taxes and things like that, your goals and what that person wants may be different, and they are different than they were today than even 5 years ago. Yeah. And so it really just depends on what you want and what you're looking for. That being said, almost everybody, if their goal is to avoid probate, there's some way to create a trust in order to do that, if that's the sole goal. But everybody can benefit from, potentially everybody can benefit from some type of trust, but everybody will benefit from estate planning in some way.
Yeah. You hear the commercials, see online, everyone needs a trust, and because of the outrageous cost of probate, and you save money and you save taxes, you don't pay anything, and that's not necessarily true. I mean, it's like I said, different kinds of trusts have different, not just tax, but vehicles in which they transfer property. And if you aren't thinking about how all these things, your lawyer is. You really need a lawyer at this point. So, final question. what do you recommend that someone does after they make their trust? We talked about this stuff. We talked a little bit about funding, but a trust is made, it's done. They walk out of your office. What do they still need to be considering?
Yeah, I mean, the important thing is really just, I mentioned before, that maintenance. Obviously, on the outset, your trust is an actual document. That's for the most part, a way to know that the trust is valid, is what the instructions are, all that. So, excuse me, keep the trust in a safe place, similar to you do with a will, whether it be a safe deposit box, what have you, somewhere you can access it at any time. Make sure those who are playing a role in your trust or your estate plan are aware. Successor trustees, those types of things, maybe they give them a copy of the document itself. Those are kind of the initial basic things, just to keep, obviously, your document safe.
Yeah.
In some way where they are. You'll likely be in contact with your bank. Sometimes the bank will have a copy and they'll ask for a copy of it, or at least a portion of the document itself. But the main things, like I said, is going to be that maintenance. Continue to review the trusts. Continue to review if the grantor or settlor is not the initial trustee. Continue to review things with the trustee. Make sure that it's completely funded. Make sure it's still following the goals that you are hoping to accomplish. And if your goals change, be willing and ready to have a conversation about maybe potentially some type of trust amendment or restatement or change to the trust if needed, based on changes in your goals, or creating a new trust for a whole separate reason. It's really with any estate plan. We've mentioned this in any webinar or Facebook Live we've done between you and I, Steve, with estate planning, is every few years you really just need to take accounting of kind of what's going on in your estate and what's changed, where your goals are, where your head is, and what you want to accomplish. A lot can happen in a very short period of time. I mean, just look at the COVID situation. Life has been very different over the last 18 months. And the way that we think about things and do things has been different from March of 2020 to now. So it's just important to keep up with all the changes and the goals and stuff you want there. Make sure you're not putting things in the trust you didn't intend to. Make sure you're not removing things from the trust you didn't intend to. And like I said, just stay focused on the purpose of the trust, and keep in contact with your attorney. Trusts are very different from wills in the sense that, you can, I wouldn't recommend it, but you can quote unquote get away with creating your own will, and still, for the most part, have your wishes followed. Creating a trust, without the advice of attorney is just not recommended in any way. And you're going to run into a lot more issues and problems down the road. So once your trust is created, if there's anything that needs to be done or changed or what have you, just make sure you're in touch with your attorney, and you'll be all good.
So life happens, like you said. Kids grow up, trustees move to Italy, all kinds of things can happen. And if someone needs to make a change, because obviously maybe their kids are now have kids, or like your best friend who was your trustee, took everything and moved somewhere, or whatever reason. It's not a difficult procedure to come in then to you and say, can I make a new trust or name a new trustee, or what do I do about the kids? These are things you can do afterwards.
Yeah. So after, considering an example, I'm thinking of a revocable trust, but yeah, you would be able to make those changes, like I said, anytime, depending on what happens, where your goals are, or if just, like I said, if life happens, and sometimes there are negative things, and how to readjust and refocus. And whether that's, if you need to create a whole new trust, or like I said, restate it, or amend the trust or what have you, you have the opportunity and ability to do so.
And, looking at our law firm, if someone's getting divorced, and they've got trust, that's a time to come see you.
Absolutely. Absolutely. I mean, like I said, blended families are is the first casualty to, or estate plan is the first casualty for the blended families.
Yeah.
Just because if you're not paying attention, assets and things are going to point to individuals or only, and leave out other individuals, or things may pass in the way that you're not necessarily want to, despite the fact that your previous document stated that it did. So absolutely, divorces, birth of new children, deaths, all those things are very important times to review and reconsider what your estate plan is, trust or will.
So folks are listening now and want to know more about this or want to talk to you about their particular situation. How they get a hold of you?
They can give our office a call at any time. 503-227-0200. And they can set up a initial consultation to discuss their estate plan and their goals, which is a free initial consultation.
I love it. Well, I think we're done. I now kind of understand the basics of a trust, and I really thank you for providing what really is a complex issue and making it easier to understand by folks like me. So again, thanks, Triston, for joining us today.
Thank you for having me.
Oh, I've always liked to have you over on this side of it. And I also want to thank everyone who's listening today. Again, for listening. We really need you to like us, to come and listen to us. We offer a ton of different stuff. And if anyone has any questions about today's topic, as always, post it here. You can even shoot me an email at saltitian@Pacific Cascade Family Law. And until next time, everyone, stay safe. Have a great day.
Thank you.